Lawyer Bernard Teko Bosumprah. And as he takes his seat, let's show him some love. Let's show him some love. Let's show him some love. So this is the whole idea, is to be able to give people to share insight on what intellectual property spans in our lives. And our next speaker here, Lawyer Bernard Bosumprah. The current Copyright Act that we have, 2005, Act 690, he was the person who was in charge to make sure that the act was passed. And that was in 2005. Can we show him some love? Show him some love. And he did so well to be able to do it. So, sir, thank you very much for joining us.
Thank you, Doc.
All right. So we want to find out, in drafting a bill like the Copyright Act, how does it start? And how do we understand it in terms of intellectual property? Because copyright is just one aspect. So that all of us will understand that process and be able to vibe with it going forward.
Thank you. The Copyright Act that we have today was not the first copyright legislation in this country.
Okay.
When we were under our colonial masters, yes, that is under UK, we were using those laws they call laws of the laws of general application. Okay. If you are in Ghana and they pass their law in the UK, it's of application to you. Nigeria, Gambia, and all of that. India, those of us were under them. Now, in 1961, when we became independent, we had the first Indigenous Copyright Act during Nkrumah's days. And then when late President Rawlings came on during the PNDC era, we had another one, PNDC Law 110, which was made in 1985. And so we proceeded from there. There were certain provisions in those laws that we couldn't just leave off. We needed to carry them along. And day by day, we belong to international organizations. They have conventions, they have treaties. Ghana is a member of UNESCO. Ghana is a member of the World Intellectual Property Organization. We have the Patent Cooperation Treaty. We have the trademark. We have all sorts of international organizations in the area of copyright and related rights and the other industrial property. And so to make the law, you proceed from what was already there. As I said, PNDC Law 110. We didn't repeal it because it was not relevant to us. But there's something we call, in the area of copyright, say copyright follows after technology. The same applies with other intellectual property laws. When I was in the Copyright Office, I don't think we have things on the YouTube and all of that. And so with time, the copyright law, what we have, if the whole thing is not repealed, it has to be reviewed in a way to meet with current trends. Because in our part of the world, passing law is not easy, because the Copyright Office or whichever agency will have to justify why the existing law will have to be changed. Of course, you do that through your minister. Okay. If you are able to make that justification, then he will take it to cabinet. Okay. And then cabinet will give approval. Okay. Of course, we have the drafting section of all laws within the AG's office, the Attorney General's office, or the Ministry of Justice. Okay. And so there is a director for drafting. Okay. So when you have the after you got the necessary approvals, first you review the existing law. Whatever is available you want to take in it, you take it. Whatever additional you want to add, you add. And more so, day by day, as I said, countries or the international community passes, conclude treaties. And so when a treaty is concluded, the first thing to do is to sign it. And then later on, Parliament will ratify it. Now, the moment Parliament ratifies that treaty, then there's something we call you need to reduce that international treaty into your domestic law. So as a certain politician, you domesticate the treaty.
Okay.
It means that you reduce it into your domestic law, which can be enforced in your country. And so that's the process. You are a teacher, so the teacher proceeds from the known to the unknown. And so that's how laws are made. And in the area of intellectual property, we rely so much on technology, both copyright and related rights.
That's good.
And then, of course, the industrial property. It relies so much on technology. So as technology changes, the law must also change. You'll be surprised that in the US, they change their copyright and other IP laws maybe every 6 months or every year or something. As and when new things come. I remember at a certain time when we were working, that is with WIPO and the other member countries, we were working on a treaty in the area of broadcasting. Those days, the Americans were talking about podcasts. And it was like because they were up to it.
Yeah.
And those days, we were dealing with traditional broadcasting.
Yeah.
Television, radio, and that. And they were already talking about podcasts.
When internet had not even been known to
No,
people.
they were already doing. And those days, of course, because we were not up to it, but we deal with numbers at a certain level. So we have to insist that they should take that out, because that is not why we were there. We were on traditional broadcasting. Okay. But now podcasts and all those things, they are relevant with us. Yeah. So now, if there's a law on those, we need to reduce that into our law. So the 205 law, by now, even if we don't repeal it, because I think there's still a lot in it which is relevant. Maybe we intentionally use words like device. Mm-hmm. As for device is device. If maybe it's a gong today, mm-hmm. and it is something else, that's the trick we use to keep the law relevant. Otherwise, by now, our copyright law could be
outdated.
It could be outdated, or maybe by current trends and all of that. So that's how laws are made. You start from what you have, and then you add. Sometimes you need no repeal. If there's so much in the law that is relevant, then all that you do is you amend. Then you amend. That one is there, and then the portions that you are amending, you make reference to them in the new amendment, so the two can be used side by side.
Okay, so in the case where an act was not repealed and then a new one is put in, does the two works hand in hand, or you need to quote the new one when you are dealing with
you
issues?
Cannot have two acts at the same time. That's why I'm saying that the current act that we have, Act 690, there's still a lot in it which is relevant. Just like when we took over, when we were repealing the PNDC law 110, there were certain things that were still repeated in this law. But then there were so many that we are living in that one. So PNDC law 110 was repealed. But if now what we have, there's not much to take away from it, then it will be referenced as amendment of the Copyright Act, Act 690. And then the preamble and everything about it will show that you are just repealing and adding. So that in that case, once it's an amendment, it will be indicated. Then in that case, the two can be used side by side.
Just like the 2008 amendment on the, what do you call it, the Bandex rule that they brought in, is substantive to the 2005. Okay, quickly, let me ask this. The issue of COSGA, and now it is no more, but people still talks about COSGA, but it's separated. What caused the separation?
Well, you know, our democracy, the thing we call democracy in Ghana, for which we are known, has affected every aspect of our life.
Okay.
The Copyright Society of Ghana, ideally, should have existed.
The Copyright Society of Ghana
should have existed.
Okay.
But the various rights holders, especially previously, music was very relevant. They, in PNDC Law 110, most of the things we referred to in PNDC Law 110 was more music.
More music, okay.
Those days, audiovisual was not very prevalent. Now we have the Copy Ghana, which are for literary authors, the photographers, and all of that. So at that time, the musicians were of the view that if they were the main proponents, why do you form a society called Copyright Society of Ghana, and they will be making use of their money?
Okay, that's the justification.
So then they, right from, in fact, there was a seminar, by then Mrs. Betty Mould was there. There was a big seminar we held at the State House. And their then president, Joe Mensah, was there. He fled and kicked up against the Copyright Society of Ghana. And that was the beginning of it. But to tell you the truth, I had always stood for we having one organization we call it collective administration of copyright. But we can have portions of, let's say we can have a board.
A board?
We can have a board for music rights, a board for audiovisual rights, a board for reprographic rights. Then you have one office, you have one organization, but you may have semi-boards. But you report to one chief executive. Now we have the music rights. They have their chief executive. They have Gamro. They have their chief executive. They have their office. They have this. Copy Ghana has their own chief executive. They have their own board. They have their own office. They pay electricity. They do this by themselves. Audiovisual rights and the performers, the same thing. Why can't we have one big organization? Maybe you have one chief executive. You may have deputies, somebody responsible for audiovisual, somebody responsible for, a deputy responsible for but you have one chief executive on top. So all the organizations, they pay one chief executive because for administrative purposes, in collective administration, 30% of the collection is supposed to be for administration. So if you take 30% for audiovisual rights, you take 30% for Gamro, you take 30% for this. They all go into administration. But now they all have, and it's an expenditure. Administrative expenditure will have to be taken before royalties are distributed.
So in a short form, it means these boards and the chief executives contribute to the less money people receive.
It is very likely. But you see, those days, when you are a public officer, there is a limit to which
you can share information.
Because if you are advising, the person can, the corporate administrator work under the Attorney General or the Minister of Justice. And we are in a democracy, and if somebody has some connections with a political party, you, the public officer, what can you do? Before you write, sometimes you are giving the kick. So, but as much as possible, if now, reflecting back, I think if they can have separate boards, right. But within the same, but now we have a structure. Everybody has his own office building. Everybody pays his staff. Everybody pays his electricity. Everybody, and all of that, which some of these things could have been reduced. So that is why we don't have the Copyright Society of Ghana. Although previously, all the right holders come under one umbrella. That was the original one, PNDC law. 110. We have the copyright side. But with democracy, everybody says no. We want to administer our own thing.
Okay.
And that caught up. Parliament
Okay.
also caught it up. So that's why we have
the last question
I'll
ask about is the Ghana Intellectual Property, either organization or authority, that we should have like one entity, just like the issue of COSGA, so that all of them can be under one place. If you go to Europe Copyright and Patent Office is just at one place. WIPO, the one we are all imitating, is just one. Trademark and everything is there. Here in the case we have where trademark is somewhere else different, patent is somewhere, copyright also is somewhere, industrial property is GFA thereabout. In your opinion, is it possible to do that? In just about a minute.
No, we have two areas of copyright. Of intellectual property. We have industrial property, which is made up of patents, trademarks, and all. And that is what is put together as the Ghana Intellectual Property Office, GIPO.
Okay.
But the GIPO, previously, I don't know the situation now, but originally, GIPO was supposed to be under the Registrar General.
Okay.
Even though it has its own offices at the State House area there. But now the Registrar General has now become more administering company and
registration of companies.
Registration of companies, marriages, and all of that. Otherwise, the GIPO office is supposed to be under the Registrar General. Now, the reason why we still should have a copyright office is that, for all you know, what we create more is in the area of copyright.
Okay.
We have our own music. We have our own, audiovisual.
But to cut you short quickly, I'm just thinking of a situation whereby you made a perfect analysis of where we have CEOs and we are paying them separately. If we have Ghana Intellectual Property Authority or organization or office, and then we have just one CEO, and then, yes, we have a Deputy Director for Copyright Office, Deputy Director for Trademark and Industrial Property, Deputy Director for Industrial Designs. Don't you think that would have also been an ideal situation?
It would have been, but in most countries, copyright and related rights they have their own office.
Yes.
One place where intellectual property, especially the industrial property, thrives so much is in Japan.
Okay.
And maybe now China. Now, if you go, you have the patent office in Japan, and then you also have their copyright office. They have a different name for it. If you go to the US, for them traditionally, the copyright office is part of the Library of Congress. So what they call the Capitol Hill, the copyright office is located at the Capitol Hill, where they have their Senate, where they have their Senate and their House of Reps and all of that is located there. But their patent and trademark office is in Virginia.
Okay, all right. Thank you very much. So now that we have all these wonderful ideas about how copyright, intellectual property offices are structured within the Ghanaian copyright space, we want to say thank you so much.
Thank you.